The remaining suspect in the Boston Marathon bombings is in police custody, and he is in police custody alive. And that means there's a whole new chapter of this story beginning tonight, beginning right now. It is the process by which police will build their case against this suspect, who they say committed a terrorist attack against Americans. The U.S. attorney saying earlier tonight that this is an ongoing and active investigation. We are told tonight that Dzhokhar Tsarnaev will not be read his Miranda rights before he is questioned, once he is physically able to answer questions. And as far as we know tonight, he's still in too bad a shape physically to be able to answer law enforcement questions at all. But in terms of what he is waiting for his Miranda, you know it from Law and Order, right? You have the right to remain silent. Anything you say or do may be used against you in a court of law. You have the right to consult an attorney before speaking to the police and to have an attorney present during questioning now or in the future. If you cannot afford an attorney, one will be appointed for you before any questioning. If you wish, if you decide to answer any questions now without an attorney present, you will still have the right to stop answering at any time until you talk to an attorney. Knowing and understanding your rights as I have explained them to you, are you willing to answer my questions without an attorney present? It is not always exactly like that, and in the movies, the person saying it usually has a much cooler accent, but that's pretty much the idea. The idea is that your statements are only admissible in court if they come after you have been told that list of things about your rights. There is, though, a public safety exception for questions that just had to be asked of you urgently for a legitimate public safety need, even if those questions came before you got read the Miranda. The Obama administration has extended the reach of that public safety exemption so it essentially can last longer to attend to the type of public safety threats that could accrue in terrorism cases. Terrorism cases, presumably they will argue, like this one. This man is not being treated as an enemy combatant. He will be on track for a federal trial as best as we can tell. But right now, he's on track to be questioned by a federal high-value detainee interrogation group. And at some point, he will be read his rights. He is an American citizen, and he will face American justice. Joining us now is Kendall Coffey. He's the former U.S. Attorney for the Southern District of Florida. Mr. Coffey, it's good to have you with us tonight. Thanks for joining us so late at night.
Well, thanks for including me, Rachel.
It became big news tonight that Dzhokhar Tsarnaev was not read his Miranda rights and might not be at the initial portion of his interrogation because of the public safety exemption. Is that an unusual decision? Would you have expected that?
Well, it's a matter of degree because, and this comes against the backdrop, as you were talking about, Rachel, of civilian trials versus enemy combatant military tribunal status. And the Obama administration and Attorney General Holt have been trying to demonstrate that civilian tools are adequate, that they're tough enough to make everybody safe. So in that process, the public safety exception seems to be evolving for terrorism purposes. For example, just to sort of track through, we remember the so-called Christmas Day bomber who was briefly interrogated under the public safety exception, but then very quickly given his Miranda rights. That got a firestorm of criticism as basically not being tough enough on terrorists. So the next high-profile event where that occurred was the so-called Times Square bomber, and he was interrogated for hours before giving his Miranda warnings, because you can ask somebody where there's a reasonably objective standard to show imminent or immediate danger to the public or to the police. You can ask somebody those kind of questions, but when are you asking about immediate danger? And is there a reasonably objective belief that there is imminent danger? And when you're basically trying to elicit a confession. And that's where it gets kind of gray. And in this case, there's a very high-profile announcement that Miranda isn't going to happen anytime soon. So whatever else we can draw from this, it's going to be a much tougher statement about the administration's approach to so-called terrorism suspects.
So you are saying essentially that they are carving out some new ground here, that they have pushed this part of the envelope before, but with this overt statement saying we are planning in advance to be so alarmed by having him in our custody once he can speak that we are going to extend the public safety exemption then. You're saying that's pushing the envelope farther than they have in previous cases.
Well, I think it is. And the Attorney General had talked about federal legislation to limit Miranda in so-called terrorist interrogations. Then there was some internal steps taken to encourage more aggressive use of the so-called public safety exception, again, in terrorist cases. So that kind of development is, something obviously that has some, I'm sure, many legitimate concerns, but it's also going to be seen is a message that we can use the civilian courts. We don't need to ship everybody down to Guantanamo or hold them off in a Navy brig near Charleston, as has happened before, by declaring them an enemy combatant. So while this kind of approach can certainly get some criticism from liberals, from constitutional scholars that the administration's taking, the administration may see it as something that's essential to preserve the use of civilian jury trials and the basic constitutional protections, even for terrorism cases.
Kendall Coffey, former U.S. Attorney for the Southern District of Florida. Thank you for helping us understand that crucial context. I really appreciate it, sir.
Well, thanks for having me.
Thank you. It is interesting. You look at the way that civilian terrorism prosecutions have gone down in this country, and you look at the underwear bomber, you look at the Times Square bomber, and there may have been controversy over when they were administered their Miranda rights, and conservatives not wanting them to have been administered their Miranda rights. But there's never been any indication whatsoever that either of them shut up because they were read their Miranda rights. They both kept singing long after that Law and Order script was read to them. It should also be noted that the military tribunals have a much worse prosecution and sentencing record, or at least much looser sentencing and prosecution record than civilian trials do for terrorism suspects overall. This week's events were another reminder that the world has gotten very, very small and very, very interconnected. So small and so interconnected that you can't really ignore parts of it anymore. We've got more ahead. Stay with us.